to start this afternoon with a hearing on Senate Bill 115, and I'll ask Jesse to give us an overview.
Thank you, Madam Chair. Good afternoon, committee. One of the two Senate bills this committee received at turnaround was Senate Bill 115. So today's bill hearing is on 115. What it does is it amends statute 592133, which deals with adoptions. And so this statute specifically changes the list of persons who are supposed to be given notice on a hearing when a petition has been filed for an independent or step-parent adoption, a private agency adoption, or a public agency adoption. So what it does is it changes these notice requirements for each of these three types of adoptions, listing out people that are supposed to receive notice for each kind. So what you can find is under subsection C, you have one, an independent or step-parent adoption. Notice goes to parents, presumed parents, or possible parents, any person who has physical custody of the child, and any legal guardian of the child. In a private agency adoption, the notice would go to a consenting agency, the parents, presumed parents, or possible parents, any relinquishing person, any person who has physical custody of the child, and any legal guardian of the child. And then in that third option, in a public agency adoption, the notice is only required to the consenting agency. And so therefore, these changes also add in subsection D that notice of the hearing under these petitions is not required to be given to the following: a person whose parental rights have been terminated by an order of the court, or a person or agency that has waived in writing that right to receive the notice. And I'm available for questions on Senate Bill 115.
Okay, thank you, Jesse. Are there questions regarding the bill for Jesse? You must have done a very good job. Thank you, Jesse. Okay, first up, proponent testimony. We have Austin Vincent with Kansas Judicial Council. Hi, welcome to committee.
Those parents are probably long gone, and becomes very, very difficult to give them notice. The end result of that problem was raised by a district court judge to our committee, is that you just can't find these people, and it can stretch out the foster care placement issue for a long time. So what we did in Senate Bill 115 is we simply distinguished between a private agency and a public agency. In other words, cases that are where the kids are in state custody and you're ready for adoption. And so in those cases where parents have been engaged, at least been given notice many, many times, notice to the parents who have relinquished is not required. Just notice to DCF. So we tried to make it clear. We tried to clean up the language a bit so that it's clear in each particular case, as has already been mentioned, that in agency public, it's just to the agency, DCF, but in private agencies, it's to the parents and others who have been involved. And in an independent and step-parent adoptions, of course, you give notice unless it's waived. I think that's pretty much all I have, unless there are questions.
Committee, do we have questions? Representative Wagoner.
Thank you, Madam Chairman. Of all the adoptions that happen in Kansas, I mean, what percent are, these public agency adoptions versus the alternative? I mean, do you have any sort of number on that?
I really don't. I know that we have a lot of kids in foster care. Okay, that's a huge problem, and so there's lots of them, but how they relate proportionally to the other types of adoptions, I don't know. I'm sorry.
If I may follow up, do you even have an idea how many adoptions like this happen? The public agency adoptions or consenting agency?
My guess is there's hundreds, if not thousands, a year over the state.
Okay.
That's a
Further
guess.
questions? Representative Wagner, did you have further questions? Okay. Representative Carr.
Thank you, Madam Chair. So is it my understanding that these adoptions can't move forward with the adoption unless those individuals that were listed on the list of those to be notified have been notified, and we have confirmation that they have been duly notified?
That would be a fair understanding, and the problem being is that sometimes you have no way of giving them notice. So what you're left with when you can't give a parent notice of a hearing is you have to publish in the newspaper, and that takes at least another month or so. And so, again, these parents have been notified many, many times of these hearings and have relinquished rights and have moved on. And months or years later, we're trying to get the kids into a permanent home. Does that make sense?
Yes, it does.
Thank you.
One follow-up. So what is the normal time frame based on the point at which you would make those notifications to those people who are on the list between that time and the time that the actual adoption would take place? What are we looking at?
Well, the statute has provided, or does provide now, and has provided for a long, long time, that they get at least 10 days notice before the hearing. All they have to do if they want to object is contact the court, bring in a letter. They can hire an attorney if they wish, but they have to do very little. They can show up and simply say, object. I think my relinquishment was involuntary. But it's pretty easy to object, I guess that's what I'm saying. Thank you.
Thank you, Madam Chair.
Representative Humphreys.
Thank you, Madam Chair. So would you say that when parents sign a relinquishment that there is ever or often a waiver of notice within that relinquishment so that they've waived notice voluntarily?
Right. The statute does provide that that parents in any kind of adoption may waive notice. Some parents simply do not want to know, they don't care, or they just don't want the pain or whatever. So they may decide and sign a waiver of notice so that they don't have to be bothered by the issue anymore. In those cases, you can proceed, but we don't always get those in DCF adoptions.
Thank you.
Representative Owsley.
Thank you, Madam Chair, and thank you for being here. To oversimplify, would it be fair to say that SB 115 is an attempt to expedite permanency?
I think it has that effect, yes.
Right.
It was raised simply because the judge who was wrestling with this problem simply said, what are we going to do? How do we give these people notice that have been long gone? And so, yes, it does speed up the process.
I mean, ultimately, that's the intent in any adoption situation, right?
Well, as long as you're protecting everybody's rights, yes. Yes, and in these cases, the rights have been addressed long before, and so notice really isn't necessary.
Thank you. Thank you, Madam Chair.
Representative Howerton.
Thank you, Madam Chair. So, how are these notices sent normally? Is it by mail, by email, or what is the?
Well, again, the statute provides that they may be sent by mail, and certified mail. They may be served by the sheriff. We've actually opened up the notice provisions that when you can't get notice in the traditional ways, the judge may approve alternative means. I haven't done this in a DCF adoption, but sometimes the only way you've got to connect with a parent is through Facebook. And that isn't perfect, but it's better than nothing. So,
So on certified mail, do you have to wait for that return receipt to be sent back? As
if the judge requires certified mail, yeah, you'd want the receipt saying they got it.
Okay, so my question is, it's not necessarily just mailing them a notice. It's you have to be notice that they received the notice. Is that correct? Is that the?
If that's what the judge requires, right, right.
Other questions? Okay, thank you.
Thank you very much. Appreciate it.
Okay, we have Matt Stevens with St. Francis Ministries. Hey, Matt.
Good afternoon. Chair Kincannon, Vice Chair Johnson, Ranking Member Ousley, and members of the committee. Thanks for the opportunity today to speak about the benefits that to children and families with the passing of Senate Bill 115. And so I'm not going to read my testimony. You guys have it. But in addition to speeding up permanency, the other thing that it does for children in the public agency adoptions is it decreases their likelihood of additional trauma. And so obviously you heard testimony about making sure that we actually get folks notified, but there are opportunities, and we have a story here where people are notified, and even though their parental rights have been either relinquished or terminated through the sync system, they still show up. And so during that time, it really is traumatic for the child. It's something that the adoptive parents don't want necessarily for the bio parents to show up. So what could and should be a very celebratory occasion turns into a very traumatic event, or the potential for a traumatic event for this child. So that's why we support Senate Bill 115. It really does clean up some of the technical language and making sure that we're not notifying parents who have already been through the sync process, really getting their rights, again, either relinquished or terminated. I did have one other piece of information. So Representative Wagner, you asked the number of public agency adoptions. In fiscal year 22, there were 948 adoptions in the state of Kansas. That is all I have for you. If you guys have
Okay. Do we have questions? Representative Humphreys.
Just to kind of make clarify a little bit, you're saying there were 948 children who were adopted out of foster care through the agency, but that does not include private adoptions or agency, non-DCF agency adoptions.
If those are just DCF adoptions.
Yeah, okay, just so the committee's clear on that. Thank you.
Further questions? Representative Wagner.
Okay. I mean, this could just be a total amateur question, but I mean, but do you not have cases where, you know, somebody had given up or had whatever authority over their child taken away, and then that they don't, all of a sudden they find out later their kid has been adopted and such? I mean, does that not ever create some sort of problem or crisis, or is that not considered an issue?
I don't think it's an amateur question. Maybe I don't quite comprehend it. So what you're saying is, if a parent is to relinquish their rights, might they later find out that their child was adopted?
Well, yeah, or that they would, I mean, you know, that they would, I mean, wonder, or that they would be dismayed. It's not just the child is in foster care, but the child has actually been adopted, that somehow that sort of finality? I mean, is that not considered a problem?
I mean, for those parents going through that process, obviously they understand what's at stake. And so usually, obviously, when we're terminating parental rights or when they relinquish parental rights, they're giving up the legal right to that child, knowing that ultimately that child could be adopted. And so again, it's probably upon us, parents, attorney, everyone else to say, you know, if you fail to follow through with case plan goals, if you cannot keep your child safe for a myriad of reasons, right? This isn't necessarily all negative about the parents, but if you aren't appropriate today and the courts have deemed, again, that we should terminate your parental rights, then that obviously is the kind of what everybody anticipates probably will happen. And maybe am I answering your question? Maybe I'm.
I think you are. I mean, I mean, still the notion of somebody who, I don't know, had second thoughts later on, or, you know, that just to have, you know, to, you know, find out in a newspaper report, you know, years later that your child was adopted. I don't know. Again, it's probably just very much a layman's, you know, perspective, but it does strike me as a little odd that they would have no notice.
So when parental rights are severed, does the judge inform the family, the parents then, of the implications of that?
So the judges would be having conversation with parents about what that means for their relationship with that child moving forward. The case teams would be having those conversations. The parents' attorneys would be having those conversations. So I don't know about at that particular hearing if that's something that's laid out and how it's spelled out, but kind of throughout the process, as you move closer and closer to termination of parental rights, then it is something that's known that your child could then be adopted. And I would hope, and you know, most of the families, they want what's best for their kids, and they don't want their children living in foster care. You know, some of the having children age out of foster care isn't a good outcome either. So the quicker we can get to permanency, kind of speaking to the timeliness, is what's going to be best for those children, kind of moving on with their lives in a known way. So that's trying to get to that permanency of adoption, which isn't our first choice, right? Our first choice is always reintegration. So how are we working to make sure that our children have the opportunity to go back to their bio parents or their parents of origin? So ultimately that's our goal. But when that cannot be achieved for lots of different reasons, then adoption is something that they should be well informed about before it happens.
Representative Howerton.
Thank you, Madam Chair. There's no reversal of once a judge terminates parental rights. Is that correct?
No, and they have the ability to appeal, right? So they have an appeal process as well. So is there, I would say no, that there's not a reversal. I think there's a very small handful of cases at some point if the parental rights are terminated very young in the parent's life and maybe their child for whatever reason didn't reach permanency through this, and they can come back into their child's lives in some way. But no, it's not necessarily I would not call it a reversal of the termination of parental rights.
Representative Carr.
Thank you, Madam Chair. So how difficult or extensive is the termination of parental rights process? Is that something that that you come in, you stand before a judge, and for instance, they tell you that that your child's been in custody, and because your child's been in custody, you owe $20,000 in back child support because the state is taking care of your child, and then we offer, and maybe I've watched too much television, and we offer, you know, as a way out, you can simply, you know, give up your parental rights, and then you don't have to worry about these things. Like, how extensive is that? A one-day process? Does it take a period of court dates? I'm just curious.
Sure. So the quick answer is vary. It's very complicated and a lengthy process. And so again, going right back to where I started, anytime a child's removed and the state removes the children, we get a referral. Our number one goal is always reintegration. And so we do assessments to make sure that those families are having their needs met. Really, our goal is to rehabilitate that family, to make sure that we've mitigated or eliminated the safety concerns that originally brought them into care. And if for some reason it's outside of the parent's control at that time, but we're talking about, I mean, you asked about a day. No, it's not a day process, and it never would be contingent on the amount of money that they have, that they owe the state in back child support. It always would be about their ability to provide a safe home for that child. So years. Obviously, our goal is to get them to reintegration very quickly, because we don't want to be custodians of these kids as long as it's safe for them to be home. That's our goal, is to get them home as soon as possible. So kind of veered a little bit onto kind of just child welfare in general, but yeah, it's not, the termination of parental rights is not something that anybody takes lightly, or something that happens as a knee-jerk reaction to any singular event necessarily.
Thank you. Thank you, Madam Chair.
Bless you. Further questions? Okay. All right. Thank you.
Thank you.
Okay, that is all the testimony that I show, either in person or written. If there's anyone else who wishes to speak to this, would like to, this is your chance. Okay, so yeah, with no neutral and no opponents, I'll close the hearing on Senate Bill 115. Okay, committee, we're going to work some bills. This time, I will open discussion on House Bill 2299 and call on Representative Humphreys.
Thank you, Madam Chair. I do have an amendment. And I think Jesse will pass it out.
Would you like to explain the amendment, or would you want Jesse to? Okay.
Yes, when you get the bill, you'll see what it is. It's really a numbering amendment. It was something that was brought to our attention, if you all remember the day that we were going to hear this bill above the line, and it was brought to our attention that there was a mistake, and I take the blame for that, in the numbering, because we had made we had done an amendment the week before, and so we had added section B1 up at the above, page 3, line 13. We had added section B1 and then didn't really address the numbering down below properly, and so this is to do that. So the way it reads now is, so on line 34, if a foster parent considered by the secretary under subsection B3A or B3B is not selected by the secretary, the foster parent may request direct placement and so on. And so if you look up and you see B3A and B3B, you find that it's only in the circumstance when the child has lived more than half of the child's life with the foster parent, or when the child has lived more than 2 years with the foster parent. When we had misnumbered it, it was more broad than that, and we really just mean for that appeal process to be very narrow, and only in the case of those 2 instances. So this amendment is to rectify that situation that we had. And I move my amendment.
Second the motion.
Okay, it's been moved by Representative Humphreys to amend, second by Representative Johnson. Is there discussion? Representative Ousley.
Thank you, Madam Chair. And I understand the mistake in the numbering from previous and the clarity that this amendment adds to it. Do we have an idea of how many cases that this would potentially impact? I guess question for the maker of the amendment.
Nope.
Okay,
No, I'm sorry.
that's all right. Representative Humphries says no.
Okay, that's going to cause me some concern is, I guess maybe it's the underlying bill, not so much the amendment, and I can wait to express my concerns until we get back to the underlying bill.
Any other discussion? Okay, Representative Humphries, you may close.
I close. Thank you.
Okay. It's been moved to amend. All in favor say aye. Opposed, no? Okay. Motion passes. Back to discussion on the bill. Representative Ousley.
Thank you, Madam Chair. And it's my understanding that with this clarifying amendment that just went on, this still leaves potentially hundreds of open cases that would now be subject for appeal with the tightened language and the retroactivity. I still think we're ignoring what a lot of the proponents said in their testimony with regards to the appeal process. I think we are discarding what the Judicial Council stated in their report. And I'd be happy to bring the committee's attention to that, but I think I'll offer an amendment first to strike lines 36 and 37 of page 3 and may appeal that decision to the Court of Appeals. Move my amendment.
Okay, we have a motion to, on page 3, line 36 and 37, to strike the words "and may appeal that decision to the Court of Appeals." Is that a second? No. Okay, we have a second from Representative Hoagland. Is there discussion? Representative Ousley, did you want to
If I could, Madam Chair.
explain?
I'd
Okay.
just like to read from some of the testimony from when we originally heard 2299. From the Foster Adopt Connect testimony, it says there may be unintended consequences to the appeal components of 2299. There is likely value in creating a path to appeal for any potential adoptive family. However, doing so would require additional time to gather, analyze, and interpret data to ensure we are informed in developing policy that promotes timely permanency and reduces instability for our children. Foster Adopt Connect would recommend the passage of 2299 without the appeal provision at this time. From the Judicial Council report, this would be page 10, anybody that's following along, paragraph 2. Though the appellate courts expedite sync cases, it can still take years before a final decision is reached. Such delay causes harm to the child by postponing permanency and is usually emotionally devastating to all people involved. My notes are in an old bundle, I apologize. From the Children's Alliance testimony, we've got 2299 provision reassessed to Court of Appeals may delay certainty for children. We understand the desire for court review of cases to ensure DCF is appropriately considering attachments it's in process, if you all understood that. However, we would ask this committee to carefully reflect on the issue of opening a path to appeal a district court's decision to the Court of Appeals. It goes on from there. From KVC testimony, if the right to appeal language is included, we would ask that consideration be given to opportunities for all adoptive resources to appeal non-selection. From the Child Division, the Kansas Division of Child Advocate testimony, Says, as noted, the KDCA has received concerns regarding judicial oversight and limitations on appeals. KDCA cautions moving forward with the inclusion of the automatic right to appeal without further analysis to safeguard that considered expansion ensures equal due process while balancing best interest and more specifically the child's time. And I think I can stop there and take questions.
Representative Neighbor.
Thank you, Madam Chair. Just for clarification, this bill, as it is written now, is not retroactive. Is that correct? Any adoption that has been made is done. Is that correct?
Adoption is done.
The adoption has been finalized.
The motion, it was amended that if there was any open case.
Open case.
Yeah.
And we don't know how many open cases there are. Is that correct? No one knows?
I don't think we know. Representative Ousley.
Madam Chair, I don't know for sure, but I can say that I've heard estimates in the hundreds, to 200 to 400.
May I ask one more, Madam Chair? Thank you. What is the rationale for taking out the ability to appeal? I'm just asking.
Representative Ousley.
Well, we just heard testimonies talking about the expediting of permanency, and the appeals court process can take up to years while a child is waiting for permanency and then would be experiencing what it would essentially be a custody battle. Furthermore, it's a one-sided, from some testimony that we received in the mail, or an email we received, submitted as testimony. I'll read from that. Decisions based on a one-sided presentation of information does not further a child's best interest. Only where competing interests are permitted to present both sides can the court determine what's best for the individual child. And in the case of 2299 right now, as written, the right to appeal to the appellate court would only be to assure that the district court upheld DCF policy and law. It would not be to re-examine the placement of the child. It would be just to look for a violation of law.
Thank you, Madam Chair.
Representative Howell.
Yes, thank you, Chair. My first question would be for Jesse, I believe, and that would be when the potential adoptive foster care parents if they were to appeal the decision to the Court of Appeals, I should say, would they be paying for this out of their own pocket?
Jesse.
Representative Howell, I would believe so. If they have retained counsel, and they would have to pay docket fees related to filing that appeal.
Okay, thank you. Can I do one more? If Representative Osley would be willing to help me understand. So we're talking about children who have been more than 2 years with these same foster parents that are wanting to adopt this child. So DCF has already determined that these are good parents. These are foster parents in good standing. So I guess I'm at a loss to understand why would a delay in leaving the child in a secure and safe place where they have bonded in 2 years during an appeal process could be harmful to that child. They're already in a safe and secure place with these parents. I mean, these children are after being in a horrible set of circumstances, they're now in a position of potentially having, I guess, 2 sets of people who want to take care of them and keep them for the rest of their lives. This is a vast improvement for them. So I guess I would like to understand better what the concern is, because I'm struggling here.
Representative Ousley.
I guess I'd lead you back to the Judicial Council report where it talks about the appellate court and the delay of permanency. Again, to read from that report, though the appellate courts expedite sync cases, it can still take years before a final decision is reached. The underlying bill of 2299 I have no issue with. I have no issue of taking into consideration the attachment, for the permanency placement. It's that appeals process that adds an extra 2 years to that child's limbo, if you will. So I guess you'd have to give me a specific incident where all these people that testified that work in this arena would have missed something when every single one of them pointed out an issue with it and advised against it.
Representative Howerton.
Thank you, Madam Chair. I can share one example of a family from Wichita who DCF agreed. There were 4, I can't see you, so I'm trying to talk to you. So there's 4 children. They were fostering 2 of them. It's a sibling set, 4 siblings. They had 2 of siblings. They wanted to adopt all 4 of them, which is what DCF agreed was in the best interest of the child. DCF agreed, the foster parents that I know wanted to take all 4 within, and the court only allowed 2 of those children to be with the foster parent and split the other 2 siblings up, and they have no recourse. And so that's what's fresh on my mind, is just that the court went against DCF, they went against they hired experts to do studies of the best placement of the child. They went against the experts, and they went a bit against what we prefer. I guess the statutes say is that we want to keep the siblings together in this case. And so that's what I'm thinking about. And I know there's other situations out there like that.
Representative Ousley.
Thank you, Madam Chair. And to that, I guess I would say that the 2299 underlying considerations for attachment should be taken care of. And if there is an appeals process within the system right now that currently exists that allows you to take that appeal up to a district court. And again, I would reiterate, if you give the right to appeal, A, it's still one-sided, but then B, the appellate court is only going to look at what the district court said. They're not going to reopen the case. And furthermore, I'm looking at my notes. Again, these notes are a little old, or they're filed in my head a little old. In the Judicial Council report, it says that no law should be, created off of one case specifically because no 2 sync cases are alike. So you need to craft sync laws broad enough that they're applicable.
Yes, go ahead.
I just want to add this: the adoption's closed on this one, so this law would not affect that situation. But so I'm not trying to get it changed for that, but that one's fresh in my mind. Thank you.
Representative Johnson.
Thank you, Madam Chair. I'd like to make a motion for discovery on the documents that he has cited as in behalf of his amendment, because they are being cited on behalf of the amendment. We should be entitled to be able to review those prior to making a vote.
Representative Ousley.
If you go into child welfare of the original date of 2299 and you look up testimony, you'll find everything that I've just cited. And what the Judicial Council report that was omitted from being submitted as testimony was laid on our desk, I want to say 2 days later. I know that's where I got my paper copy, is there was a paper copy on each one of our desks.
May I respond?
Yes.
Because it is submitted at the late moment and on behalf of his amendment, and we are not available to those documents in writing, I'm just requesting a copy from him, and it should be submitted if I ask.
So Representative, this is all testimony that was received when we had the first hearing on this. So it's all in the file for this bill, when we had the hearing for it on the S drive.
Yes, thank you. I understand that, but because it has been submitted at a later time in behalf of a new motion or an amendment, it becomes different, and it is subject to discovery and time for us who would like to read that and confirm it, because there may be information in that that we have not had time to study because we were not aware that this amendment would come. Thank you.
Representative Ousley.
Thank you. And the Kansas Division of the Child Advocate is dated February 8th, 2023. The KVC Kansas testimony for 2299 dated February 8th, 2023. We've got the Children's Alliance proponent testimony on 2299, February 8th, 2023. Foster Adopt Connect, House Committee on Child Welfare and Foster Care, February 8th, 2023. I did read one sentence from an email that I believe we all received at a later date and time. And that was one sentence regarding decisions based upon one-sided presentations.
Representative Humphries.
Thank you, Madam Chair. So for a variety of reasons, I would oppose this amendment. But I do have a question that you seem to say that you thought that there might be hundreds of folks that would appeal their decision from the district court. Can you cite where you got that information?
Madam Chair.
Representative Ousley.
If hall talk is a sufficient answer, I would give that. And also, I did find the sentence I was looking for in the Judicial Council report. Said the committee agreed that any sync statute cannot be too narrowly written. Sync statutes are intentionally broad because each sync case is unique. If the sync statutes were too narrowly written, it would hamper the sync system ability to meet the needs of each individual child.
Representative Humphries.
Thank you. Thank you. Well, I think hall talk is interesting, but I'm having trouble coming up with hundreds just in a year. We just heard how many adoptions are in a year, and we know that, and we have had the statistics, about half are either reintegrated with family or go to relatives, and maybe another half go to foster parents. And then how many of those foster parents or those ones that didn't, the foster parents that didn't get that decision, how many of them didn't choose to, instead it was reintegration and that was fine. And then of those, how many of them, the child lived with them half of their life, and then how many of them actually would go to the district court and would have an adverse decision for them. I see it whittled down, and I think it's very important that people have an appeal process, but I don't think it would be I don't see it clogging up the court. So about that piece of it. And then about the piece of why the appeal process is important, it's because the foster parents don't have a voice in this regard during the best interest staffing. And this gives them a voice. And we all have gotten emails from people similar to what Representative Howerton said. I know I've gotten them. I'm thinking of a case with a foster family in Sabetha that had a child for 3 years, and everything was going great. And they were the chosen family for the child to be adopted when the parental rights were terminated. And then something happened at the very end. Someone made an appeal for a 19-year-old half-brother. A 5-year-old went to live with a 19-year-old half-brother. And in that case, the foster family had no recourse. They had been chosen, and then someone along the line made some sort of informal appeal. And this foster family, they were told one day, and the last time they've heard their child's cry was I want to go back to mommy and daddy down the hall. And it's heartbreaking. And so I don't know that, I don't think it happens constantly, but I do think it happens. And we've all gotten emails about that. And most of these families don't want to go public because they're afraid of the repercussions that might happen, as we've seen in recent days. But it happens, and these families need a voice. They need recourse for when those decisions are made. And that's why I would oppose the amendment. I understand the appeal process in this bill is a controversial piece. I understand that. But I think the best interest of the child is 3 times written in this bill. The court shall be guided by the best interest of the child. And that's what the purpose of this is. And in this case, the foster families need to be able to make an appeal so that the best interest of the child can be considered. So I would oppose the amendment. Thank you.
Representative Howell.
Thank you, Chair. I also just have to say that I am opposed to this amendment. As I sit here and consider these things, I'm remembering that when DCF first has a child that they're looking for placement, the first place they look is family. That is the first place they look, as they should, okay? But then when that child is moved to foster care, we all know we are beyond desperate for foster care parents. They are the heroes of Kansas. They are taking on such a heavy burden and such a hard job, such a heart-wrenching job to give love and care to these traumatized children. And then and just out of respect for the service that they have provided to our community, I feel that giving them an appeal and letting them have an additional opportunity to have a voice is just cannot be overlooked. Thank you.
Are there further discussion on the amendment? Representative Johnson.
Yes, thank you, Madam Chair. I oppose this amendment. This is going to take away a right that is so necessary to improve our situation. I also feel that the amendment is brought at the last moment, not allowing us to have time to properly address the way we would like to. So I will absolutely oppose it. Thank you.
Further discussion? Okay, Representative Ousley, you may close.
Thank you. And I'd like to address, there are no rights taken away. Currently, there is no right to appeal to the appellate court, not for the foster parents, not for the bio parents. And trying to refer back so that I don't misquote anybody. KVC Kansas, if the right to appeal language is included, we would ask that consideration be given to opportunities for all adoptive resources. It doesn't say for foster parents. I point back to the Judicial Council report discussing crafting sync laws on one case, to the number of open cases for the retroactivity portion of this. The amendments, page 4, line 21 of the bill, the amendments made to this section by this act shall be construed and applied retroactively to all proceedings pending before a court on the effective date of this act. In the Judicial Council reports in fiscal year 2022, DCF estimated that 303 BISs were held, 247 of the BISs involved one prospective adopted parent or sets of parents, 64 of the BISs involved multiple prospective adoptive parents. So of those 2022 numbers, 64 of them had multiple prospective adoptive parents, which I will interpret to be that there's 64 potential cases that could be impacted by this. Again, foster parents do currently have a voice. There's an internal appeals section, and then you can appeal that outside of DCF up to a district court. I apologize for bringing this amendment up late. It is not a new discussion. Hall talk is interesting, and sometimes that occurs on the floor as well. I know that I discussed this with the bringer of the bill previously, and I would have offered this amendment the last time that we were working this bill, but the motion to pass out favorably was made before I could get the chair's attention. So I guess the question I would ask the committee is, do you want an appeals process for foster parents, or do you want the consideration of attachment versus blood versus bond? Because the underlying bill, 2299, without the appeals process, has a bunch of opponents. I think you leave this appeals process in there and you potentially lose the work that resides in the underlying bill. So keep that in mind as you vote upon this, because I think the original intent of the Judicial Council request and report was to look at the bond versus blood issue. And we have recommendations that came out that I will say 2299 without the appeals section, reflects the general consensus of. And I would like to see us get back to the reflection of that report without any obstacles or creating opponents from dismissing the proponent testimony. So, Madam Chair, I'd close on my amendment.
Okay, you've heard the amendment. All in favor, say aye. Opposed, no? No. Chair's in doubt. All in favor, raise your hand. Opposed, please raise your hand. Okay, the amendment fails with a vote of 5-7. Okay, back on the bill. Is there any further discussion? Okay, Representative Humphreys, you may close.
I
Yeah, you have another.
Bill favorably.
Oh, yeah, we don't have a motion yet. Representative Humphreys.
I move that the committee passes the bill favorably, House Bill 2299. As amended. Thank you.
Okay, it's been moved by Representative to pass out favorably as amended, second by Representative Johnson. Is there discussion? Representative Ousley.
Just to reiterate, with the retroactivity on this and the appeals process, I can't support the bill. And I'm sorry for that, because I do think it's a worthy discussion, and I think the Judicial Council report has a lot of good in there. So I'm sorry to see the committee not take that into consideration, and I will be a no vote for 2299 as amended.
Further discussion? Okay, now Representative Humphreys, you may close.
A couple points I want to make is I really appreciate what the work that the Judicial Council did, and our bill was very much based on what they did. The Judicial Council chose not to introduce their bill. I don't know why. That was their decision. The report was not omitted by me or anyone else. And so I just would say that I appreciate what they did, and really that we based everything on what they did. Now, the other thing I want to make very clear is this bill has nothing to do with the case that came up last fall. Well, it doesn't have, I'm not going to say it has nothing to do with it. The origination of this bill, the thought behind it, 4 years ago, the couple that I mentioned to you from Sabetha, I found out about that case at least 4 years ago. And since then, I've been working on it, since then have been doing research on the science of attachment and what that means, and introduced or had the revisers work on a bill in 21, introduced a bill in 22, went to the Judicial Council this year, 23, where we have made progress on it. And so the thing that happened last fall, it was a picture of what we have been trying to address, but it absolutely had nothing to do with that one case. And I really wanted to make that clear. The other thing, I just want to address a few things that we've all gotten a lot of emails, especially in the last day or so. And some of the emails, I don't know what version of the bill they're looking at, because I'm going to think they did not misinterpret everything intentionally. So I'm going to give them the benefit of the doubt that maybe they were not looking at the most recent bill. Because some of the things we heard was we're not taking the best interest of the child into consideration. Like I mentioned before, it is mentioned 3 times in this bill specifically, when deciding an adoption, the best interest of the child, the secretary shall be guided by that. The court shall be guided by. The secretary shall give preference to the best interest of the child. That's what it's about, is the best interest of the child. And so that's why I'm not sure what version they're reading. And then the other thing I think maybe not reading is, as you all know, we did an amendment that did, in the first year of a child being in custody, the preference for adoption is given to relatives. And so we most certainly did have that in there. It was a good, I agreed, we need that, especially at the beginning. We need to bend over backwards to find relative and kin, blood, all of that. And then this is about what happens afterwards when the child has been with the foster family for 2 years or more than half their life. And so I don't want to dismiss the emails we've gotten. I understand people are invested in this. Some of it have been by judges and different people. I've run it by a judge in Sedgwick County, and he agrees that it's a good law, and that some of the comments that we've heard, folks just were not reading the most recent version, apparently. So with that, and knowing that everything is not perfect, but I think we have a good product here, and we're making an effort to think of what is in the best interest of the child and think about how to go forward with that. I would move my amendment, and I close.
Yeah, that wasn't on an amendment. So,
Amendment. I move my motion and close. Thank
Okay.
you.
All right. All right, you've heard the motion. All in favor, say aye. Aye. Opposed, no? The ayes have it. The motion passes. Okay, committee, we are going to consider House Bill 2194, enacting the Representative Gail Finney Memorial Foster Care Bill of Rights. I guess I forgot to have you do an overview of the last bill, but we jumped right in. Do you want to go over this real briefly? Okay, well, Jesse just wants to know if you have any questions. We all do remember this bill. This is our Bill of Rights. I think I'll just open up with discussion with my amendment. the amendment.
Sure thing, Madam Chair. Hello, committee. Jesse with the Revisor of Statutes Office. The amendment before you proposes a definition of a kinship caregiver, and then in that subsection B, when it talks about the rights of foster parents, it includes this kinship caregiver to that group of people who will have the following rights. And then it has some other qualifications, but when it comes to this kinship caregiver, what you'll see is in section 3 is the sync definitions. And so in new subsection R, it has kinship caregiver. It means an adult that the secretary has selected for the placement for a child in need of care with whom the child or the child parents already has close emotional ties. And so that mirrors the definition right above it, kinship care placement. So that placement just talks about the arrangement, but it does not define the person. And so that person is now being amended into this subsection B in 2194. And since there are some of these rights that are existing in current statute, section 4 and section 5 are some of the statutes that are referenced in subsection B that only relate to foster care parents. So when you're amending kinship caregivers into subsection B, you would be amending by implication, and so we're just best practice is amending the statute so there's not an inconsistent application between section 1 and the current statutes. And so that's the kinship caregiver aspect of the amendment. And then what you can find is new language under subsection D, that the secretary shall provide notification of the rights created under the new section 1, and information for filing complaints for foster youth, for the foster parents and kinship caregivers that the section relates to. The secretary is also required to make these rights available on their website, and then each child welfare management provider shall make these rights as well, physically and digitally available. And then in new subsection E, what it has is that this section shall not be construed to create a private right of action independent of the sync code, and it may be enforced through equitable relief as part of a corresponding revised or a part of a sync. So that's stating someone out of thin air that is not associated with a current sync proceeding cannot state so-and-so is not following section 1. I would like to file that. So that's not possible. It has to be associated with an existing sync proceeding, and the only type of remedy is that equitable relief. So we're talking there's no monetary damages that a court could award. Instead, this is more of like an injunction or a request to do something of a child welfare management agency or the secretary. And so then you have some of the kind of technical changes to the title and the repealer.
Okay, committee, sorry for the big balloon amendment, but I would just say that this clarifies that the caregiver rights apply equally to both foster and kinship caregivers, and ensures the rights are known and enforceable without overburdening the court dockets with separate causes of action. So with that, I will move to amend. Second? Okay, so I made the motion to amend. Representative Underhill seconded. Is there discussion? Okay, I'll close on my amendment. All in favor say aye. Aye. Opposed, no? Okay, thank you. So then on page 3, I have another amendment that did not print on that page. Jesse, do you want to explain that one?
Yes, thank you, Madam Chair. Jesse with the Revisor of Statutes Office. So if you use the amendment that was just handed out, what I can do is I can tell you exactly what the amendment's going to be. So on page 3, in lines 2, the amendment would strike all the language after discriminated, and then in line 3, strike all the language up into in. And after with, in line 4, you would have the Kansas Act against discrimination. And so that amendment strikes that list of qualities and instead states just in accordance with the existing Kansas Against Discrimination Act, which is already being cited with that KSA 44101.
Okay, I'm going to make the motion to amend. I'll say it again, on page 3, line 2, by striking after discriminated, all the language through the rest of line 2, and then all of line 3 until the word in. And then on line 4, after the word with, we insert Kansas Against Discrimination Act. Kansas Acts Against Discrimination. Okay, I've made the motion, second by Representative Underhill. Is there discussion?
If I could ask Jesse.
Representative Humphreys.
So in accordance with Kansas Acts Against Discrimination and amendments thereto and federal law, so do we leave in KSA just the language, KSA 44-1001 at SEC?
Jesse?
That statutory reference would be left in.
So it would say in accordance with the Kansas Acts Against Discrimination, KSA 44-1001.
Yeah, and
Okay.
probably with a comma in
A
between.
comma, okay. Got it. Okay, thank you.
Further discussion? Okay, I'll close on my motion. All in favor say aye. Opposed, no. Motion passes. Okay, is there further discussion? Representative Johnson.
Thank you, Madam Chair. I have an amendment I'd like to submit. She passes that out. This is a simple amendment, making sure again that we have established federal Indian Child Welfare Acts appropriately to this particular. And so on the end of line 4 on our first page, it would say, children in need of care and foster parents applying the Federal Indian Child Welfare Act to the Representative Gail Finney Memorial Foster Care Bill of Rights and amending the Kansas statute and repealing the existing section. And on page 4, again, it's just simply adding the repealing of a statute. And on the last page that you have will indicate, doesn't show the line, but Representative Gail Finney Memorial Foster Care Bill of Rights. And then this will, I believe, help us to, as we continue to support the Federal Indian Child Welfare Act in all of our different laws. I would make a motion to amend 2194 as listed.
Okay, it's been moved by Representative Johnson to amend, second by Representative Neighbor. Is there discussion? Okay, Representative Johnson, you may close.
I close.
Okay, you've heard the motion. All in favor say aye. Aye. Opposed, no. Motion passes. Back on the bill. Is there further discussion? Representative Humphreys.
Thank you, Madam Chair. I'm sorry. If we could go back to the second amendment. Jesse, could I just read to you what I understand it says so that I'm clear, the one that we didn't have for sure? So we go back to page 2, section C, and I'm just reading at the end. Unless otherwise ordered by the court, such foster parents and kinship givers shall have the right to, I'm skipping down to line 2, not be discriminated in accordance with KSA 44. So should we keep the word against or no?
So Representative Humphreys, I received feedback from our proofing department that the against is not the proper grammar to be
Okay.
used in that sentence.
Oh, okay, shall not be discriminated in accordance. Okay, well, thank you.
Okay, further discussion. Representative Neighbor.
I'm sorry, without further amendments, I would move that we pass House Bill 2194 out favorably for passage as amended.
Okay. It's been moved to pass out favorably, second by Representative Johnson. Any further discussion? Representative Neighbor, you may close.
Thank you, Madam Chair. I close.
Okay, you've heard the motion to pass out favorably as amended. All in favor say aye. Aye. Opposed, no. Okay, thank you. We are short on time, committee, but we've been asked to get this 2443 kicked out. So I'm going to bring that up for discussion. Does anyone have any amendments? Representative Howerton.
Would you like me to start explaining or just?
Yes.
So this is a pretty lengthy balloon amendment. I tried to take all the comments that we heard when we were hearing the bill and then just kind of put it all together in one amendment. So when everybody gets a copy, the first amendment is changing the number of members on the board to an odd number instead of an even number. So it's changing it from 12 to 11. And then the second amendment is changing kind of the structure. One thing I noticed on the makeup, so the board, I think, did a great job of trying to be a comprehensive view of all the different parties involved in a child in need of care case or DCF case, however you want to term that. But they forgot the biological parent. And so I thought that would be a good needed view on this board, and also an adopted parent. So I kind of changed it. We had to change the number of appointments by the Chief Justice to just 2 to make that an odd number to get the 11 members. So we changed it to just leaving it as an experience of respondent parents counsel, and then legal experience in representing a child in need of care. And then the governor, we changed her, or his, I guess, in future terms, to the appointment of a professional experience with social service agency in a rural area and then an urban area, and then moved the professional experience with a mental health provider, moved that up to the governor's appointment. And so that she would have 3 appointments, and then the next one is, I gotta take my glasses off, I apologize, now I can see. Okay, so the president and minority leader of the Senate shall appoint an individual who's a child in need of care, we left that. And then we added the biological parent to a child in need of care there, and then a member at large. And then on the House, we changed their appointments to the Speaker of the House and Minority Leader of the House will appoint a current or former foster parent, and then added an individual who has adopted a child through a Kansas court and a member at large. So it kind of gives that outside perspective. I think that's important. I have an outside perspective on this committee, and I just think that's a good balance there. And then we added on page 3, we added that the board may suspend or remove any member of the board. So this is basically, Representative Lewis brought that there was no way to remove a board member. So we added that language in there. And then we also added that at the board's initial meeting that they shall appoint a chairperson, vice chairperson from among the board members would appoint that. And we thought that would be needed just to clarify what we expect of them, and then the renumbering of that. And then the last change was on page 5, well, second to last. We added the filing of a complainant or referral of a concern to the office shall not establish any relationship between the child advocate or an employee of the office or a complainant of any other party involved in the action. There is no privilege as to any communication between the child advocate or an employee of the office and a complainant or any other party involved in the action. So with the requirements of the child advocate to be either an attorney or a social worker, that those that experience could be there, there can be a conflict between attorney-client, someone they've represented in the past, or as a social worker, they have a code of ethics that they have to follow. And we wanted to protect the child advocate and to establish plainly that it's not a relationship that would have to do with social work or a client, attorney-client privilege. So we added that to protect the child advocate. And then the last one is, I just wanted to give a bigger pool for people to draw from, and I added, had demonstrated extensive experience in the practice of child welfare in the field. So this is where it's talking about the qualifications of who should be the child advocate. And that is the extent of the amendments. I'll stand for questions.
You want to go ahead and make a motion then to?
Make a motion to move the amendment.
Okay. And we have a second with Representative Hoagland, or question? Okay. A second from Representative Humphreys. Now, we have questions. Representative Hoagland.
There's some variance on what you read from your page to what we have written on ours.
Oh.
This word is different. You used and instead of or. Do you want to read what she gave us to see if you agree with
Yeah, could I get a copy of that? I guess I'm reading from Jesse's first before the came out. Thank you. Yes. I apologize. That was, I guess they went through some kind of a process, proofing process, and I had the unproofed amendment. So, okay. Yeah. So this is through the proofing process. I apologize. The filing of a complaint to the office shall not establish any relationship between the child advocate or an employee of the office and a complainant or any other party involved in the complaint. There is no privilege as to any communication between the child advocate or the employee of the office and a complainant or any other party involved in the complaint. Thank you.
So it's your
Yes.
same intent.
So same intent, the proofing, maybe Jesse could clarify the difference, but yeah.
Jesse?
Sure, yeah, Madam Chair, so some of the differing on the use of the word action or complaint. Complaint is the word that's continuously used throughout the Office of the Child Advocate. That's the only form in which they receive something. They don't initiate any actions, so using the word action could imply something in the court that could be construed. So complaint is the best word to be used there. And the complainant or any other party, the person complaining or any other party that the complainant has drawn in due to that complaint.
Okay. All right. Representative Humphreys? Okay. Yes.
So thank you. I really appreciate the representative bringing this. And, you know, I had a concern about the list of the committee, and I felt like there, you know, maybe we might need someone who was administrative or financial or something. And so I really appreciate the member at large that the Senate can appoint or the House, so they can sort of see who, you know, what kind of skills are lacking. And I really appreciate that. And thank you for bringing the amendment.
Okay, further discussion? Okay, Representative, you can close on your amendment.
I close and move my amendment.
Okay, you've heard the motion to amend. All in favor, say aye. Opposed, no. Okay, the amendment passes. Is there anyone else that has amendments? Okay, Representative Neighbor.
Thank you, Madam Chair, and thank you for the carry of bringing the amendment with corrections. With that, Madam Chair, I move that we pass out House Bill 2443 as amended.
Okay, we've got a motion to pass out favorably. I've got a second from Representative Howerton. Any further discussion? Representative Johnson.
Thank you, Madam Chair. I just think this was a bill that started my very first month in this committee. It is a bipartisan bill. And I think we all supported it from the very beginning because of our care and the original sponsor spent years working on this bill. And I think this is a culmination of his effort. Thank you.
Further discussion? All in favor, say aye. Opposed, no. Okay, motion passes, the motion passes to pass out favorably. Okay, committee, we are done for today, and we're going to meet Monday, Tuesday, and Wednesday. Oh, we have minutes to approve. You've received March 6th and March 8th minutes in your email.
I move approval of March 6th and March 8th.
Representative Neighbor moves to approve. Representative Howerton seconds. All in favor say aye. Aye. Opposed, no. Okay, so thank you. Thank you for passing the minutes. And we are adding a day next week because we've got, first of all, we're going to have the Boys and Girls Club Youth of the Year, and the nominees will be in the Capitol that day, and they are going to come in to speak to us. And as well as we had a hearing earlier this year. Representative Humphreys had a bill in Judiciary that it doesn't replace the GAL, but it has, the foster child has their own attorney. And there was, we had some testimony that came from a woman and an organization from out of state, and they are going to be in Kansas. And so we're going to have a hearing here so we can learn more about it. The bill itself died at turnaround, but I think it's a movement nationwide, and I think it would be important for this committee to hear about it. And she is an excellent speaker. Apologize, Representative Lewis, you will have heard this twice, as well as Representative Humphreys and I, but she does a really great job of talking about what this issue is all about. So with that, we are adjourned, and see you Monday.